Stewart and Rod at
Right.
litigation financing and all the questions you may have about that. The developing partner section's next substantive programming will be on November 14th at 11 Eastern. It's going to be on the art of delegation. More information to follow. We will also be having a networking call sometime in probably November, not scheduled yet, where we're going to be interviewing a couple of victims, Roger Barton and others, about um, how they started their practice, how they built their business, what wisdom they've learned along the way, everything you'd want to know but are afraid to ask, that sort of thing. So stay tuned for that. But today we're all about litigation funding, and I'm very pleased to have Stewart and Raj with us. Stewart Ackerly, I know personally. He works at Statera. Stewart is based in Washington, but Statera's got significant operations in Chicago for the Midwesterners on the call. Stewart is a director. He's responsible for origination efforts, business development, policy initiatives with Statera, specifically interested in bringing in new firms, new attorneys, people who haven't maybe used litigation financing before, and bringing them into the fold, which makes him perfect for those of us who haven't dipped our toes too deeply into these waters. He's a frequent speaker at bar associations, law firms, CLEs, all sorts of things. Was very kind to accept our invitation here. And then we have Raj Duvvuri from Omni Bridgeway. Phil Antis's firm has worked with Omni. I don't know Raj personally, but funnily enough, when we were looking for candidates, Phil recommended Raj, and then Stewart did the same thing. So, uh, some of the best reputations and people. Raj was a litigator at Baker Botts and other places. Then he went in house where he handled, was responsible for a lot of big stakes litigation. Now he is an investment manager and legal counsel for Omni, where he evaluates cases, I assume risk, and helps guide them through how they go about evaluating a case. So we have kind of the client development and the, I'm not going to say writing team, but at least evaluation of risks and benefits of potential litigation funding cases. So we've got a very well-rounded group in terms of what they're able to offer. They welcome questions. If you have any, you can either put them in the chat if you feel like you're interrupting the flow, or they're both very receptive to just blurt it out. And so please feel comfortable to ask questions if you have any. And we're also going to do, I don't like to spend time in the substantive programming on introductions, but if you want to drop your name, firm, location, primary practice area in the chat, please feel free to do so. And again, if you have any questions, you can either drop them in the chat or you can just speak your mind. So with that said, I will turn it over to Stewart and Raj. Thank you very much for coming, and take it away.
Thanks, Ryan. Thanks for having us. And Bree, thanks for organizing. I'm going to try to share. Raj and I put together a deck. So let me see if I can successfully share that here in 1 minute. And let me start it. All right. Can folks see that? All right, great. Well, thank you all again for having us. Raj and I are really excited to be talking with you all today. We've done these before in other venues, and I think one of our favorite audiences is kind of younger partners who are in the midst of their careers and thinking about things like the business of law, not just the practice. And I think Raj and I see more and more every day that litigation funding can be an important part of the business of law and building a book of business. So we're excited to talk about that with y'all today. We've got a pretty straightforward deck here. We're going to cover a few topics. First off, just what is litigation funding? Then we'll talk through how it can be useful, how it works, just from a kind of nuts and bolts perspective, so you have a sense of the financing process. And then we'll also go through some of the ethics and regulatory considerations around funding, which is a pretty regular topic on places like Law 360 or law.com. So we'll give you an overview of that. And like Ryan said, if you all have questions or comments, feel free to interrupt us, anytime during the presentation, or just drop something in the chat, and we'll try to save some time also at the end to answer any questions that folks have. So without further ado, well, Ryan already gave us our introductions.
Not to be 10 mute.
So let's just jump into what is litigation funding. So, first off, just kind of why does funding exist? And it comes down to kind of the traditional hourly fee model that most lawyers utilize. And that creates sometimes a little bit of a disconnect between clients and law firms, especially when it comes to affirmative litigation or plaintiff side litigation. Oftentimes a client is going to prefer some type of contingency fee. And that may be because the client is a small business and doesn't have the resources on hand to pay lawyers its hourly rates. And maybe the company or client does have the resources, but it would rather put that money into its business rather than paying law firms to litigate claims with uncertain resolution dates and uncertain resolution amounts. And when you look at surveys, especially of in-house legal departments, an overwhelming majority report that they forgo meritorious claims because of costs. And why do those cost barriers exist? Law firms are traditionally pretty risk averse, and they like the hourly billing structure. Firms are generally and partners are generally compensated based on hourly billings. The law firms are pretty cash-based businesses and kind of year-over-year businesses that aren't built to think about kind of longer-term investment horizons that may be required for a contingency case. And another piece of it is law firms don't have outside. It's just the partners or owners. There's and debt financing is often pretty unattractive. So that can create, those two factors can create a disconnect where funding can kind of step in the middle and help solve that by essentially creating a synthetic contingency fee where an outside funder like Omni or Statera can step in and cover the legal fees and costs of pursuing a claim, and help the client offload that cost and that risk so they don't have to shoulder it, or they only have to shoulder a small portion of it. And at the same time, it allows the law firm to continue receiving hourly fees, or at least a portion of its hourly fees, while still winning that business and not having to take on the full risk of a contingency, and also just the opportunity cost of taking contingency matters. We see law firms and lawyers all across the country that have more than enough hourly work to go around. And so when they're approached with a contingency fee need or an alternative fee arrangement need, sometimes it's just not worth the cost of giving up the certain hourly billing, even if there's potential upside, in those contingency matters to have a really significant recovery for your client and for the law firm. There's just too much uncertainty around doing that. And so a funder like Omni or Statera would step in and provide the funding for the legal fees and costs on the case. And typically the funder is only going to get paid back its capital and its return if the client is successful in the litigation, which generally means the client gets money back. It's not just that they win a judgment at trial, and then have to spend years collecting on that judgment. It's they pay a funder back typically when they get money in the door from a settlement or collection on a judgment. And then also critically, and we'll talk about this more later, the funder typically has zero control over litigation decisions or settlement decisions. So, a funder is not like an insurer on the defense side that's got veto rights over settlement decisions or litigation decisions, or you have to seek their approval. Funders are passive third-party capital providers. We do not have those kind of approval rights over anything involved in a case. So, why do clients utilize funding? I mean, I mentioned a few just from the cost perspective, but this lays out, in more detail kind of why we see more and more clients, especially companies and others, pursuing funding. First, it helps level the playing field with potentially more well-resourced counterparties on the other side, and ensuring that your client has the money necessary to see a claim through to its reasonable conclusion, wherever that is. Second, it allows clients to retain the best possible legal talent, not just who's willing to take a contingency or who they can afford, but really think about, who's the best law firm, best lawyer to pursue this case based on the likely recovery value. And it also helps clients preserve working capital so they can put their money to other uses in the business rather than having to put it towards litigation. And it also allows those clients to potentially monetize litigation assets. I think we see more and more in-house legal departments thinking of themselves, or trying to think of themselves, not just as cost centers, but as potential profit centers, or at least revenue generators, and using affirmative litigation to generate revenue for the business. And then, in terms of leveling the playing field, I think this also gets back to a broader concept of trying to provide greater access to justice through funding. As all of you are aware, lawyers are expensive, and pursuing claims is expensive, especially if you have to go through discovery and go to trial. And so funding helps level the playing field, so companies and clients that don't have the resources or don't want to spend precious resources can pursue those claims. And we've included here a quote from Justice Eileen Breinstein from the New York Supreme Court, who sadly passed away a couple of years ago. But she considered a case involving funding, and has this quote about why funding exists and why it's important, which I think is always very helpful in just trying to place funding in the broader context of litigation and civil justice in the United States.
Thank you. And so it's very nice to meet you guys. Thanks again to Bree and Ryan for the opportunity to speak with everybody. Nice to see a couple of familiar faces. And thanks, Stewart, for kicking that off. I mean, Statera and Omni are very similar firms. It is funny. It is a big and growing field, but it is also still a small field, as we'll get to. Funding has become very more and more useful and recognized as a tool for plaintiffs and plaintiffs' firms. And yet, over the course of time, the funding market has sifted into a few different categories, and both Statera and Omni are some of the companies that have really made a name for themselves and have done well over time. And it's really great to meet you guys. Generally speaking, when is litigation funding useful? For you guys, the folks on this call who are outside counsel practitioners, the answer is it is useful for you if you have a plaintiff call you and say, hey, look, I got a great case. I would like you guys to represent us. Will you do it on a contingency fee? And if your answer to that is, it's a good case, but for the reasons that Stewart mentioned earlier, I just don't think that a contingency fee is going to work here. We are going to need to get paid hourly. Okay. Litigation funding is helpful for you in that moment, because instead of saying, and so I'm sorry, you probably ought to go call a plaintiff's shop or a contingency fee firm. Instead, what you say is, you know what, y'all ought to call Statera or Omni. Call Stewart or Raj, and what I think they can do is they can bridge the gap so that you don't have to pay for your case, but you can still get the right lawyer, us. So from your standpoint, if there's one thing you take away from this call, I hope that it's if a plaintiff calls you with a case and you can't take it contingency fee, but you want to do it hourly, this is your opportunity to win that business. Okay, call Stewart, call me, call another reputable funder, and they can make it happen so that you get paid hourly doing plaintiff's work, and your client is happy because they get to have the lawyer of their choice prosecute their case properly. Now, like I said, over the course of time, litigation funding split into roughly 3 segments. Okay, one of them is consumer litigation finance, and so that's for like the plaintiff's cases that you would normally think of: car wreck cases, med mal, things of that sort, personal injury. Okay, then you have collective actions. This is a bit of a newer development. You've got class actions, mass torts, things of that sort. These are cases that are still sort of typically within the domain of plaintiffs' firms, not necessarily commercial litigation firms. And yet funders are slowly going more and more into that area as well, and saying, okay, look, how can we provide funding not just for a single case, but for a docket of cases, and see if there's a recovery. And then kind of one of the more established mainstay areas of litigation funding, what Stewart's shop and my shop do primarily, is commercial litigation funding. So it is for law firms like Gordon Arata, right, where Phil and Adam work, like Williams and Connolly, where Stewart works, and Baker Botts, where I work. These are traditionally defense side commercial litigation shops, but their clients more and more are saying, you know what, just because we're a business, just because we're a patent owner or whatever, doesn't mean that we can't bring claims of our own. We've got claims. We deserve justice. We deserve our day in court, and yet the Gordon Aratas and Williams and Connollys and Baker Botts of the world don't necessarily always do contingency fees, but we want to use those guys on our antitrust cases, our patent cases, our breach of contract cases, and so on. And so, you do just firms in the litigation finance world, you'll find, do tend to sift into 3 different buckets, and a firm in one bucket does not necessarily do work in the other. So, for example, Statera and Omni both primarily do commercial litigation funding. Okay, we also do some collective actions, but we do not do consumer litigation finance. Generally speaking, for the med mal cases, car wreck cases, and things of that sort, there's a whole separate realm of litigation funding firms which don't cross over much. They don't do much commercial work, and the commercial firms don't do much of those cases at all. And there's reasons for that have developed historically, some ethical reasons and whatnot I don't need to go into. But just the thing to bear in mind, the takeaway from this slide is you do sort of have a bit of a 3-segmented industry with different firms in each segment. Statera and Omni, and many of the other ones that you would traditionally have heard of in the media, will be your commercial litigation funding firms. Can you go to the next slide, please? Okay, so when and how does litigation funding come about? Okay, one of the things that I hope you guys take away from this is that it is actually an incredibly flexible tool. Okay, so if you have a single case, for example, you got a single breach of contract case, your client calls you and says, hey, I got this case, I need to sue. That is a paradigmatic example of when you would call a litigation finance firm and say, hey, look, we got this case, it's worth such and such amount of money. It's got a fairly hefty budget. The client would like it covered. Can you guys pay us to do it? Classic. Companies like Omni, Statera, other particularly larger, more well-established commercial funders also will frequently fund dockets of cases. So that's, for instance, let's say a patent case. Let's say you're an oil service. You have an oil services client, for example, like a Baker Hughes or somebody, and calls you and says, we've got a portfolio of patents that we think are being infringed upon, and there's a handful of different targets. We're going to bring 3 or 4 different lawsuits, on those patents. Will you guys fund it? Will you guys handle it? And you say, you know what? Let's see if we can get a funder on board. Funders like Omni, Statera, we very typically do dockets of cases too, and it's actually a great deal all around because from the funder's standpoint, it reduces our risk. Right? We don't have to worry about one crazy judge or one crazy jury or one mistaken ruling. We got a number of different courts and a number of different claims, again, with slightly different facts and so on and so forth. And that reduces our risk, and it reduces the pricing then that we impose on the plaintiff. The return that we need in order to clear our hurdles then goes down because the risk is down. So do bear in mind, whether it's a single case or a group of cases, and obviously in a group of cases, oftentimes the budget is likewise going to be higher. Litigation funders can step in and work in either context. Another thing to remember, some people have the misconception that if you're going to call a funder, you need to call them on day one. Otherwise, the case is already started, fees are already being paid, they don't have any interest. That's not true. Litigation funders often will step in and start providing funding at the beginning of a case, pre-filing, or after filing, after dilatory motions, well into discovery, even before trial. I'm sure Stewart has had this experience. I've had this experience. A client will call and say, this lawsuit's going great. But, we didn't necessarily expect it to take this long or to be this expensive. We got to head to trial now. And the trial budget's going to be $1 million or $2 million. And we do not want to run out of steam now. We think this case is only getting stronger. Will you guys step in and pay the trial fees? And the answer is absolutely we'll do it. Okay. And so sometimes, in fact, people call after a trial and they say, you know what, we've won this case. It's fantastic. The other side wants to appeal this for another year. We step in and pay for the appeal. Point is, you call it anytime, from pre-suit all the way till after judgment. Funders will be happy to step in and pay, whatever the budget is at that stage. Likewise, funders don't just cover fees or costs or both, that we do whatever is needed. Okay, so very frequently, for example, we have law firms who say, you know what, we like contingency fees. We're fine with that, but what we don't like is we don't like outlaying our own firm money to pay for experts and costs and travel and so on. So we're fine to take the case on a contingency fee, but we'd love for you guys to pay the costs. Y'all pay the experts. We don't want to outlay money from our own coffers. Okay, we'll do our time unbilled, but we don't want to outlay any money. That's a perfect scenario for calling a Statera or an Omni to come in and pay those costs. It's a smaller investment from the funder's standpoint, but it works exactly the same way. One thing too to know, oftentimes, depending on the strength of the case, funders will monetize the value of a claim. This is something very, very few lawyers understand and very few plaintiffs understand. But let's say a plaintiff calls you and says, I've got this great case, okay? And you tell them, yeah, look, it's going to take a couple of years for you to get a recovery. Okay, I think it's a really strong case. I think you've got a meaningful recovery coming, but you're not going to see the money for 2-3 years. That is just the reality of litigation. Now the answer is a little bit different. The answer is that may happen, or if you call a litigation funder, they might be willing to write you a check right now for a portion of that claim. They're not, if your claim is 20 million, they're not going to write you a check for 20 million. They're not going to buy your claim necessarily, but they'll write you a check for, a couple of $1,000,000, and, you can enjoy that. It's still your case. You still prosecute it. Hopefully if the case wins 20 million, hopefully you still get 20 million, but they'll write you a check right now for some portion of it. And you can enjoy that money risk-free during the pendency of the case. And, just like any other funding structure, if the case wins, Omni or Statera will, they'd be happy to get their investment and a return back. But, if the case loses, you got to enjoy that money this whole time. You don't have to pay it back. So please do know, if a plaintiff calls you with a case, let them know there is an opportunity for them to get paid out some of that claim on day one itself, or at any point through, maybe before trial, maybe after trial. It is possible for them to see their money before the end of the case using litigation funding. And then the last thing I'll mention, law firm portfolios. This is a way for a law firm, one of y'all's firms, to call and get funding directly for the firm. Let's say you've got a handful of plaintiff side contingency fee cases. This is a different scenario. This is not the scenario where a plaintiff calls you and says, hey, I need hourly fees covered. This is, you guys have some contingency fee cases. You're looking at some hopefully healthy recoveries, some healthy contingency fees coming down in the next couple of years. Okay. One thing you guys can do, if you call an Omni or a Statera or another, commercial litigation funding shop, they can write you guys a check, again, help you fund your operations, de-risk your portfolios a little bit. And similarly, if you guys win, the cases and the money starts flowing in for your contingency fees, these litigation funders, we will draw our return out of your contingency fees. But in the meantime, you've gotten some cash flow. So rather than saying, all right, we're putting out all this money for years and years, hopefully we'll get a payday 3 years from now. A Statera and Omni can pay you consistently over the course of time, some portion of your money, and de-risk it that way. Look, if the case doesn't work out, you've still gotten to enjoy some of your fee money along the way. Can you move it forward, Stewart? Mm-hmm. Thank you. Okay, and so here are just some real world examples. Okay, I mentioned earlier, if a plaintiff calls you with a case, and they need coverage, call a funder. Here are some specific examples of how it's used. Patent infringement, classic example. Client calls you, like I said, and says, I got some claims. It's going to be very expensive. It's going to take a long time. perfect example, perfect situation to call a litigation funder, and they will pay those fees, those costs, whatever the case may be. One of the cases we looked at was a bad faith trespass lawsuit, right? I know Phil and Adam know this kind of case really well. You see it all the time in the oil field. You know, oil company calls and says, I think so and so company is trespassing on my acreage. They're basically stealing my oil. Those are very expert heavy cases. They're expensive. They take a long time, but you cannot call, you know, your billboard plaintiff's personal injury lawyer for those. You need a commercial litigation firm to do those. And that, you know, it takes time and it takes money. That's a perfect scenario to say, you know what? Okay, I would, you know, you're a good client. I'd like to represent you. I'd like to get paid hourly. Let's call a funder and have them pay some of those fees and costs. Insurance claims are a very typical type of litigation funding scenario. You got a client who, you know, let's say you know, they had a machine destroyed during transportation, or a building burned down, or whatever the case may be. They go against their insurer and they say, you know, this was a catastrophic loss. We got, you know, millions of dollars in recovery that we needed. The insurance company's jerking them around. You know, a lot of times, you know, those losses can really, really destroy a company waiting for the insurance company to pay up. That's a scenario where you can come to a funder, and the funder can not only pay for your client's insurance lawsuit, but they can. That's a perfect example of claim monetization, where they can say, hey, look, I know you need money right now to survive as a company until the insurance company pays up. We'll pay you a few $1 million to keep you guys running. And we'll also pay for the costs of your insurance lawsuit. And hopefully the insurance company, you know, gets it right and pays back and pays penalties and interest and so on and so forth.
Hey, Rob, can I jump in and ask a question? Do you mind?
Please.
So I'm really excited about this for our clients. We don't litigate, but we've got commercial clients, businesses. A lot of them now have a primary lender that has a lien on all their assets. And how do you guys come in and securitize your loan when there's a primary lender in place?
So we do need to have the senior right on the litigation proceeds.
So you have to get a release
on the litigation proceeds only, not other assets, but for that claim. And it's usually very easy to get those because we're the people who are enabling the litigation to happen, right? And so it is the funding that is enabling the litigation proceeds in the first place. And so that's usually, it's usually not that difficult to get that through.
Yeah, it's just to piggyback off that, Julie. It's a great question, and like Omni and Raj, we run into that regularly with clients, and our experience is similarly that most lenders will pretty quickly agree to let us have priority as to the proceeds of the specific case that we are providing financing for. So it's usually kind of very discreet as to what the funder has priority for relative to the lender. And from the lender's perspective, you know, there's nothing lost for them, because absent our funding, there wouldn't even be a chance at this kind of shot on goal to get an additional recovery for the client.
And so do you do an intercreditor agreement, or do you do just a release of that lien on the claim?
We find it just kind of depends on whatever the arrangement is. I mean, sometimes it's just a release, and we can kind of do whatever works best for the lender and the client.
Okay.
Can you go to the next one, Stewart?
Mm-hmm.
And that's great. Please jump in with questions anytime. Okay, this does not have to be a one-way conversation. Your questions are very welcome. Okay, another classic scenario: trial verdict on appeal. Okay, I'm looking at a case like this just now. Okay, you guys take a case to trial, you win, fantastic, right? You have a judgment in hand. The other side appeals. You can tell they're going to drag this thing out for another year or two. I mentioned claim monetization earlier. This is an exact scenario where that works great. Funder may not have even heard of this case. You can call them after the judgment for the very first time and say, look, we got this judgment in hand. It's for $10 million. This client wants to see some of its money now. It wants to avoid some of its appellate risk. What can you all do? And Stewart's shop, my shop, other litigation finance firms, they will gladly say, all right, look, you got a $10 million claim. I'll tell you what, we'll write the client a check for $1 or $2 million now. And they don't have to worry. I mean, it's de-risked. Even if they lose the appeal, they get to keep that money. You know, from our standpoint, the case has already won at trial. It's a pretty good case. If it wins after appeal after a year or two, it's a good investment. Hopefully we'll get a nice return on that money that we put in. But it allows the client to enjoy their money immediately, not having to wait. And it really shifts the leverage between the parties, because now the defendant doesn't get to say, ha ha, we're just dragging this plaintiff, we're just going to drag him around for 2 years. Plaintiff's actually sitting pretty. They've got a portion of their judgment, they're doing fine. International arbitration. Litigation finance is quite common and well established in international arbitration. Those cases invariably need expensive, high-powered law firms, and they require expensive arbitrators, expensive experts, expensive travel, and all the rest. They also typically are high-stakes disputes, right? Complex disputes, and so it's a very classic scenario for if somebody calls you, says, hey, I've got this big old, it's going to be a big saga, it's going to take a long time and a lot of money, call a funder, they can make that happen. And then lastly, the portfolio. As I mentioned, our financing is not just for impoverished plaintiffs, it's also for firms. So for example, my old firm, Smizer, Kaplan and Veselka, they were prosecuting a number of contingency fee claims. They called us up and said, you know what? We've got some really good claims, but they're going to pay out different amounts over different periods of time. Some of them are more risky than others. We'd like to smooth out our inflows a little bit and de-risk a little bit. And we said, sure, yeah, we'll pay you a little bit of money over the course of time. And our collateral will be your contingency fees. So if you win, we'll get our return from those contingency fees. If y'all lose your cases and the contingency fees never come in, well, too bad for us. But at least you guys made some money on those cases over the course of time. Can you jump to the next slide, Stewart? Okay. Like I mentioned at the outset, litigation finance, it's not that old of an industry. I mean, in reality, in America, it's maybe a decade old, and it has grown by leaps and bounds. The market has evolved a good bit, but it has moved in one direction, and that is growth. These numbers are actually not even, I don't even think these are the most recent numbers. I don't know if those have been tabulated yet, but over $15 billion has been invested by investors into litigation finance firms to go out and deploy and earn a return on. And in 2022, $2.7 billion was invested in litigation. And that number, I'm sure, is only larger now. It has become more and more prevalent. I'm in Houston. I would be hard-pressed to think of a commercial litigation practice in Houston that has not called me at some point looking for litigation financing. It's just very, very common. And why not, right? For commercial litigation firms, this opens a whole new practice area. A lot of them were confined to doing defense work. Now, all of a sudden, they can do all the plaintiff's work they want and get paid for it hourly. All right, can you go on to the next?
Yeah.
Thank you. Okay, how does litigation funding work? I've just a couple of slides here. Number one is, how are companies like Statera and Omni even set up? Like, how does this business work? The business of litigation funding, how does that work? And then secondly, how does a process work? If you call Stewart or you call me and say, hey, I want funding, what's going to happen then? So I'll talk about those. First, the business context. I just mentioned, all this money, billions of dollars have poured into litigation finance. Here's what it is. We're set up like venture capital or private equity funds. Okay, we are an investment shop. So we have funds that, private investors, institutional investors, hedge funds, others put money in. Like one of our biggest, Omni's biggest investors is the Harvard Endowment, right? So they put in hundreds of millions of dollars into our fund. And basically what they say is, just like they tell their venture capital and private equity funds, they tell us, okay, here's some of our money, go out, earn a return on it. That's their mandate to us. And our job, Stewart's job, my job, our company's job, is to go take that money and to earn a return for our investors. That's our business. Okay, so they put step one, the investor puts money into the funder. That's Stewart, that's me. Then what we do is we take our fund Stewart's fund, I don't know exactly where it is, probably tens of millions of dollars. Omni's is a few $100 million. What we do, we take, the individual calls that, Adam might make, whoever else my old colleagues at Baker Botts would make. And, they say, hey, look, I need $2 million for this case. Hey, I need $5 million for that case. My client wants a check written to them for $3 million pending appeal. And one by one, we'll make those investments. And plaintiff by plaintiff, investment by investment, we will deploy our fund. They take that money, they go to court, they fight, they pay their experts, they pay their lawyers. And, ideally, if the case wins, the money that generates our returns, the funder's returns, our investors' returns, comes from defendants. So at the courthouse or in settlement, all of these plaintiffs, they go and they settle their cases, right? And hopefully, they spend a couple of $1 million in fees and costs, but they get a judgment or settlement for, 5 or 10 or $20 million. And, the plaintiff keeps, obviously most of it, that's their fair share. But companies like Statera and Omni, we will get a return on our investment, right? So we paid out, $2 million for fees. Hopefully we get 3 or 4 million back, and we give that money back to our investors and they're happy. So that's the flow. Investors to funders, funders to plaintiffs. Then the defendant pays the money. It comes back to us and back to our investors. That's the business. And lastly, the process. Okay. So one of you calls and says, hey, I've got a case. It's going to need a couple of $1 million. Our fees are going to be $1.5 million. Experts are going to be another half. What's going to happen? First thing we're going to do is we're going to sign an NDA. Stewart will explain why. It's obvious. It's obvious. It's obviously creates confidentiality. There's no downside to anybody. It's a smart thing to do. I'm sure you guys already do that. But there are additional ethical reasons and protections that generates, and Stewart will go into it. Once the NDA is signed, step one is it's a couple of weeks long. We'll do kind of a high-level assessment of the case. We don't overturn every stone. We don't look at every document. We don't talk to every witness, but we'll do a high-level assessment. Okay, do these claims add up? Okay, what does the budget look like? What do the damages look like? If the budget for the case is $2 million and the damage model is $3 million, it doesn't make sense to take funding, because even if you win the case, all of the recovery is going to come to the funder. That's no good for. It's good for the funder, but it's not good for the plaintiff. So we take a look and say, is there enough of a recovery at the end of the day to justify the amount of funding? Is this a meritorious case? Needless to say, if Statera invest in losing cases, we go broke. Our investors are very unhappy. So we can only invest in meritorious cases. And so we scrub the merits, we do legal research, we look at the complaint, we look at other obvious documents, the contract, and so on. At the end of step one, after a couple of weeks, if our high-level review suggests that, this is a good case, I think this plaintiff has a real claim, there's merit there, there's damages there, the budget looks reasonable, this firm is a reputable firm, we think that it's a good claim worth pursuing, worth putting our money in, we issue a term sheet, okay? The term sheet is a simple 2-page document, but it contains the guts of the agreement, the funding terms, which is, here's how much we'll pay. We'll pay the $2 million, $1.5 million to Gordon Arata, and $500,000 to, the experts and costs and so on. And in return, this is what we want back, right? So if the case wins, we want a 10% contingency fee, or we want, some multiple of our return. We want 2x of the money, some multiple of our investment. We want 2x of the money that we put in, whatever the case may be. Why do we do that? That's really, the whole agreement is really just that simple. We put money in and we want to get our money out. How much is that going to be? If the parties are comfortable with it, they sign a term sheet, and they sign the term sheet, it's non-binding, and then we go into a diligence process. The diligence process is usually a month or a little bit more, and that's when Stewart and I, his team and my team, will overturn every stone that we can. We'll look in more detail at the documents, at the evidence. We might talk to a witness or two. We will likely hire counsel of our own to conduct legal research if there's legal issues we need expertise on. And we will also, during that period of time, negotiate a litigation finance agreement. That's basically the same financial terms as in the term sheet, but fleshed out with all the bells and whistles. So now it's like, a 20 or 30 page proper financing agreement. If the case continues to look good after diligencing it, and the parties, agree to the terms of the financing agreement, then step 3 is, we'll sign the agreement and we start funding, and the money's out the door and off we go. And the case, hopefully proceeds well. Hopefully it wins and everybody's happy at the end.
Right. And just before moving on to the ethics piece, just a little one addition to Raj's point is, every funder is a little different. So, I mean, it's always important to understand a funder's process, and in our process, Statera very closely mirrors what Raj outlined there. But certain things about a funder, like, do they actually have the money to finance your case, or what's the approval process look like, or things like that, just so you understand, your client understands kind of how that is actually going to play out. And I think it's always a worst case for everyone if you get to the end of a diligence process after a month or two, and the funder's investment committee says, actually, no, we don't like this one, because then everyone spent a lot of time and effort trying to get that done. And the other thing I just wanted to add is, Raj alluded to, wanting to make sure there's sufficient kind of recovery value in the case. And I think that's something that damages is probably where we say no to the most cases, where there's just not enough kind of hard conservative damages to justify or support the asked for investment. And I think most funders are pretty conservative when it comes to that, because kind of a pretty worst case for a funder is if you get to the end of a case, the recovery is far less than what everyone expected, and the funder is going to take, the funder's return entitles it to all of the recovery, because one, that's just not fair for the claimant, for the client to not recover anything, and two, it really affects the incentives of the client in particular. If they're on the courthouse steps and receive an otherwise reasonable settlement offer, but their funder is going to take 80, 90, 100% of that settlement offer, it's not unreasonable for that client to say, I can try to go to trial and ring the bell and get a bigger recovery, and might only be a 5% chance of success, but it's better than not, better than giving all of this settlement to my funder. So I think funders are trying to be very diligent to avoid those situations, because we want the best outcome for the client at the end of the case. So
one more question before we switch to ethics. So how do the draws work, right? How do you know how much to fund and when?
Sure, I can jump in real quick, and Raj can provide additional color. Typically for a single case, we will deploy money as the client sends us the invoices kind of monthly from the lawyers or the experts. So kind of mechanically, for the law firm, it looks almost the exact same. They kind of send their monthly bills to the client forwards them to the funder will then wire the money to the law firm, is kind of the general route. For portfolios or other structures, it can maybe look a little different, where you might have quarterly deployments of agreed upon amounts, or the law firm can ask for certain amounts up to a limit. But typically for a single case, it's kind of deployed as needed.
That's helpful. Thank you.
Sure. So turning next to ethics and confidentiality and regulation, I think, the first question I had when I was when a former colleague recruited me into Statera was, is this allowed? I was coming from a pretty defense-oriented firm. I had done some plaintiff side work, but we never used funding, and I just frankly didn't know that much about it. And it, as I first thought about it, I was like, well, aren't there rules around fee sharing? Or I kind of remember this concept from law school and professional responsibility class called champerty and maintenance. The upside and kind of endpoint here is that funding is almost typically always allowed in most jurisdictions, especially on the commercial side. But there are some very important issues to be aware of when thinking about funding for a client or for a law firm. First, champerty and maintenance. These are ancient doctrines that relate to a third party financing a lawsuit and having an interest in the lawsuit. And states have either scaled back these doctrines or abolished them, or they're just simply not at issue because funders don't have control over the litigation or settlement decision, or they're not purchasing the claim to pursue it. And I'll provide a little color in the next slide about New York specific Champerty statute. But generally speaking, Champerty maintenance are no longer impediments to funding as long as the funding is structured according to best practices. Next is fee sharing. So Rule 5.4 of the professional rules typically prohibits a law firm from sharing its fees on a case with a non-lawyer. So in the typical commercial kind of single case financing that Raj was talking about, where a funder is providing money to a company so that company can use the money to pay lawyers and experts, Rule 5.4 and fee sharing isn't implicated because the law firm is not sharing its fees. The client is sharing its recovery in the case with the funder if it's successful. So, because the funder doesn't get paid out of the law firm's recovery, there's no fee sharing implication. In the portfolio context, where a funder is providing financing directly to a law firm for some part of its book of business, ethics committees and bars that have looked at this have typically said that as long as there are at least 3 or more cases in the portfolio, that fee sharing is not going to be an issue. That can vary by jurisdiction, but I think as we've looked at it and think about it, once you're talking about multiple cases, it really doesn't look much different than a law firm getting a line of credit or taking other financing from a traditional bank. I mean, that bank's going to get repaid from the law firm's revenues, which are its fees. And so, in the law firm context, Rule 5.4 typically doesn't come up when there are multiple cases that are part of the funder's collateral package. Third, usury. Again, in the commercial context, this typically is not an issue because its usury restrictions are typically focused on consumer financing involving just an individual. Oftentimes the limit, the amounts at issue in a commercial funding will exceed the limits of state usury laws. And then also, most funding is not set up as a loan. It's a non-recourse obligation. There's only an obligation to pay the funder if the litigation is successful. And so that non-recourse nature of the financing will often take it outside the reach of state usury laws. And then the other key thing, and I think Raj and I can't emphasize this enough, is just control. And a commercial funder should never have control over litigation or settlement decisions, and the lawyer should maintain his or her independent judgment and loyalty to the client. And that issue of control is at the heart of a lot of these issues, and avoids when the funder is in the background and has no control, it will obviate a lot of these concerns. So just really briefly, this is New York's Champerty law. It's New York judiciary law, Section 489. We can share these slides after the presentation, so I don't want to go too deep into it. But New York's law is not atypical, but a couple of important points. New York Champerty law only relates to the purchase of a claim. Typically what Omni and Statera and most funders do is just, they're not buying the claim. We're not becoming responsible for litigating it ourselves. We're just providing financing for the client to pursue the claim on its behalf, and the client continues to control and own the claim. New York's Champerty law also has a safe harbor for transactions that are worth over $500,000. So again, that kind of suggests that this statute's really focused on more consumer type financing for smaller dollar amounts. On Rule 5.4 with fee sharing, some of you may have seen that a few months ago in April, the New York City Bar's Professional Responsibility Committee actually came out with a recommendation to amend Rule 5.4 New York to expressly allow law firms to secure and use litigation funding for specific cases. I think there are a few key points from this recommendation. One, it recognizes that legal funding from a funder like Omni or Statera is really no different than the other types of financing that law firms utilize every day from a more typical commercial bank. It also recognizes I think implicitly that legal financing from a funder can be superior in certain ways to more traditional funding, primarily in that it's non-recourse, and it often doesn't have the same kind of personal guarantees from the partnership that a more traditional line of credit may have. And I think the chair of the Professional Responsibility Committee also noted that this recommendation is another way to increase access to legal services by trying to make them more affordable for more people. And that's certainly something that is part of kind of our ethos, is just that we're trying to help clients and companies pursue meritorious claims that they wouldn't otherwise pursue. So in terms of confidentiality, again, this is something that I think most funders take very seriously. A lot of us, Raj and I included, are former trial lawyers. I did plenty of defense side work, so I was on the sending in of discovery requests and trying to make life difficult for plaintiffs. The last thing we want for our clients and for ourselves is to be the subpoenas and third-party document discovery. And fortunately, there's a very strong and kind of overwhelming trend for U.S. courts to deny or severely limit discovery of legal financing documents and communications with a funder. And there are three kind of primary bases on which courts will deny or limit that discovery. The first is just a lack of relevance, that the fact of funding or a client's communications with a funder simply aren't relevant to the underlying claims at issue in the litigation. The second is work product protection. So there you have a lot of courts will say it's not relevant, but even if it were relevant, it's protected by work product. And, and I'll get into this in the next slide of kind of how to ensure you qualify for work product protection. But that's certainly the basis on which, we feel most comfortable relying in litigation, other than, lack of relevance. And then the last is attorney-client privilege with the common interest exception. Now, to be perfectly candid, there's less developed case law on the common interest exception and whether that applies between a funder and a client. So, what I'll get into on this next slide is, typically we will ensure and kind of structure our communications and documents to ensure we have work product. And the first way to do that, Raj alluded to this in the process slide about how the process works, is you put a non-disclosure agreement in place. That's the first thing we send over to a counterparty or to a law firm when we're approached about a case, is we put that NDA in place before any confidential information is shared. Courts that consider this issue will have generally said that an NDA is necessary and often sufficient to preserve confidentiality and deny discovery requests, because it establishes the work product protection, that there's very low likelihood of that information being shared with a funder, being disclosed to anyone else. And so it qualifies for work product, because almost any situation in which you're calling a funder, litigation is underway or being contemplated. So you'll fall under that part of the rule. The other piece, and this gets to the attorney-client privilege, is we always advise clients and their lawyers to share only information that is attorney work product. Sometimes that information will also be subject to attorney-client privilege, but what we want to avoid is being part of any kind of purely attorney-client communications where your client is just laying bare its soul about everything it's ever done wrong in its existence. We don't want to be a party to that. We like to see things like pleadings or key documents that are in or going to be in evidence, damages analysis, especially kind of completed expert reports, and anything else that's available. The other kind of best practices here to make sure in the term sheet and financing agreement that they expressly state the funder has no control over litigation or settlement. And then obviously know your jurisdiction. Some courts or arbitration rules require disclosure of certain information about financing that are generally intended to avoid judicial conflicts. And so you just want to know whatever state or arbitral tribunal you're under, that the relevant rules. And very quick, I'll go over a few of those. There are different regimes for reporting or kind of public policy requirements. Almost all of these are targeted at consumer litigation funding, that bucket that's focused on kind of personal injury or medical malpractice claims. And so typically these aren't going to implicate a commercial financing, but it's always good to be aware of kind of what the relevant rule or regime might be in whatever jurisdiction you're in. And then finally, just a few kind of practice pointers when you're thinking about funding, just kind of going down your ethics regulatory checklist. You want to confirm that funding's permitted in whatever jurisdiction you're in. Then you want to make sure you're complying with relevant statutes and case law and ethical rules. You maintain confidentiality through that execution of an NDA. You determine whether disclosure is required under the relevant court rules or arbitration rules. And then, again, most importantly, you ensure the client maintains control over the litigation and that the lawyer exercises independent professional judgment. So that's the end of our formal presentation. I know we're almost at the end, but there are a couple minutes, so we're happy to take any questions, or, I mean, also if you have questions, you can also follow up with Raj and me afterwards.
So I have one question, and first of all, I think we very much appreciate getting this slide deck, and if you give it to me or Bree, we can distribute it to the people who attended. We also Primaris recorded this, so we'll make it available to our members, 2,500 lawyers and 145 law firms across 51 countries. A lot of those are big law refugees, just so you know. So Primaris lawyers are among the best I've ever come across. I've been around. So my question is this. Anytime I put a budget together, I feel like it's educated guesswork at best, because you don't know what the other side's going to do, what the court's going to do, the 100 different ways a case can go sideways that are completely beyond your control. So what happens if you, despite all your best efforts, you provide a budget to a funder and halfway through the case, you realize that budget is no longer realistic and you're going to run out of funds before the finish line? What do you do in that kind of scenario?
Go for it.
I can jump in. I mean, it's a great question, and legal budgeting is far more art than science. So, and we try to be, on the front end, we try to be very conservative with the budget estimates and kind of over budget as much as possible to ensure there's going to be sufficient room in our financing commitment. Typically, we'll have the law firm be on some kind of a discount also. What that discount is, it might be 20%, it might be 50%, whatever kind of the law firm's risk profile and risk appetite is. And part of that is designed to help create some incentives on the law firm to make sure that, it's only billing what it needs to, and kind of keep that in check, keep the team, from rapidly expanding. And I think, part of this is also, when you talk about big law refugees, we find that, we do deals that involve big law, regional firms, little small boutiques, that this most often comes up with big law, where you're able just to kind of build big teams and you just kind of throw bodies at problems. We typically find that more regional and kind of boutique firms are just a lot more nimble at navigating these issues. But if it comes up, and it does, for us, it's just trying to spot it early. And, we're not in the business of kind of line iteming bills. When the invoice comes in, we're not going through and being like, what was this 0.6, what was this 0.1 hour for? All we look for is what's the burn rate, kind of what's the spend rate relative to the commitment, relative to where the case is. So we try to spot those kind of issues early. If it looks like the law firm's just burning through the budget early, we'll try to just flag it with the client and with the law firm and just sit down and talk about, all right, here's where we are. Here's a potential plan to go forward, whether that involves, it could involve additional financing if the case supports it. It could involve the client pitching in a bit more if they have the resources. It could involve the firm, taking more of a discount or agreeing to a cap in exchange for more of a, success fee at the end. And there are a lot of tools to try to address it. I think the most important part is that there's kind of a relationship of trust between the funder and the client and the law firm, so everyone is working together to figure it out.
Thank you so much for the presentation. I'm Raf Sauti from Malawi, Africa. I just want to appreciate how well spread or how far litigation funding has gone in as far as reaching to Africa. because we do find ourselves in situations where we have cases that need financing against big multinational corporations, and the litigation strategy of most multinational corporations is to drag the litigation as far as it can go. And so I was able to identify with your presentation when you said that most merited cases are left because of the question of costing. So I just wanted to really appreciate how thoughts are towards extending to Africa and how that is working so far. Thank you.
Raj, I'm going to let you take that one because y'all probably have more reach there than we do.
Sure. Yeah. I mean, it is remarkable. I mean, litigation funding, it does work worldwide. I mean, Omni is one of the larger ones. We have 20 offices around the world, including in EMEA and elsewhere. And so our funding reaches everywhere. We're happy to look at cases in any jurisdiction if they have merit, and we think that the recovery is there, then we're happy to invest in it. Like Stewart said earlier, I mean, it's an access to justice issue, and that's a problem everywhere.
Yeah, it's the only. I would just add that it's important to know. I mean, kind of do a little diligence on funders you may reach out to, because at Statera we're primarily U.S. focused, and we'll do international arbitrations, but we typically look for some U.S. nexus in the dispute. Whereas other funders like Omni or others have a much more just international reach and will do purely international kind of non-US based cases. So some of it's just funder specific as to what a funder will focus on. But as Raj says, I think there's certainly cases financed in Africa and around the world.
I have one last question, and people can jump in. We try to make these things stay on time, but if people have questions and Raj and Stewart are willing to indulge us, we can stay on for a couple more minutes. So this is a two-part question. The first part is, do people, or do you think it's appropriate for a law firm considering funding to retain a different law firm to specifically advise the client on whether to seek funding? Or do people normally play the role of both advisor and actual litigation counsel? And the second question is, I'm hearing more about the role of insurance in litigation funding space. I'm not quite sure how that all fits together. Maybe you can say a few words about how insurance is being used in your space as well.
So I'll take the first one. In general, the law firm that's representing the plaintiff in the litigation is almost always the lawyer that works on the financing arrangement too. I have seen it done differently. There is an argument to be made that the plaintiff ought to have an independent advisor, since the law firm's interest and fee structure and all of that are implicated to a degree. But that said, I have hardly ever seen that been done, and it hasn't created a problem that I've seen. I don't really think it's that big of an issue. That's just my own experience. I don't know if Stewart has a different take.
Yeah, that's the most typical structure we see. I mean, I would say kind of more recently, we've started to see more clients engage an outside, either transactional lawyer or there are other kind of advisors in the litigation funding space that can advise clients. And we're agnostic. If they want to bring in their transactional lawyers out there that specialize in litigation finance, and frankly, sometimes that can help move things along more quickly because they are very familiar with funding agreements and kind of know what the big issues are or what to spot. Whereas you sometimes get litigators who just, they like to mark up a document because that's what they're getting paid for. And they may not know why certain provisions are in there when they're just kind of standard in a litigation finance agreement. And on the insurance question, it's a really good one, and it's a fascinating part of kind of the whole litigation landscape. And actually, my co-clerk works for one of the insurance brokers out there at CAC Specialty, so I've kind of gotten to know it pretty well through him. There's been a kind of over the past, really kind of 2 to 3 years, a kind of an explosion in interest of insurance companies of insuring judgments. So there are kind of a couple of areas. The first is insuring a judgment. So let's say your client won a $100 million patent verdict. They could go and get that verdict insured, meaning that an insurance company might say, we're going to insure this verdict for $60 million, so that if you go up to the federal circuit on appeal and they decide, nope, invalid, or it's only worth 30 million, that the insurance company will pay the difference up to the 60. You pay for that. It's not cheap. The premiums are pretty expensive, but a lot of companies will pursue it to de-risk the verdict, and because you can borrow against that insurance policy. So if you had a $60 million insurance policy on your $100 million verdict, you might be able to go take that $60 million insurance policy and borrow $20 or $30 million to put in your bank account right now. And that can often be attractive enough to warrant the premium cost of the policy. The other place where you see it, well, other places where law firms taking out insurance on their own portfolio of cases, especially contingency cases, where they might have a portfolio of contingency cases with $50 million of expected fees. They could potentially take out insurance on that and again borrow against that policy. Some funders will take out insurance on their portfolios, and then occasionally insurance companies will do kind of, well, as I understand it, they will sometimes do single case insurance kind of pre-judgment, so where you haven't gotten a judgment yet, but if the case is incredibly strong, you might be able to take out an insurance policy before a judgment is issued. There's been some challenges in the market because there have been a few very large judgment preservation insurance policies that recently were triggered because very large verdicts were overturned on appeal. And so I think there's kind of some movement in the market about what the rates are and kind of what kind of risk insurance companies want to cover. My impression is that a lot of insurers are moving away from kind of the single case judgment preservation policies to more portfolio-based policies that just have more diversified risk, more collateral. But Raj, you may have additional color on that, but that's
yeah, I mean, that would just be a larger discussion. I think that you covered the main points. The only thing I'll just add is I do think it's evolving. We'll have to see where it lands, but it's worth a look.
Yeah.
Thank you. Any other quick questions? Going once, twice, sold. So thank you very much, Stewart and Raj. This has been very, very helpful. And when you send us the slides, make sure it has your preferred contact information on it, because I'm sure people will want to reach out to you when the need arises. For developing partner section members, our next substantive call is November 14th, 11 Eastern. And I gave perhaps not enough color to the delegation topic. It's actually going to be taught by Doug Brown, who is a leadership coach, and he specializes in developing tools and techniques so that you can efficiently delegate work with minimal supervision and maximum quality. So I think it's going to be a very interesting program. And stay tuned for our next networking call, which will be announced shortly. So thanks, everyone. Have a wonderful day.
Thanks, Ryan.
Thanks, everybody.
Great presentation.
Thank you.